All right, good evening. My name is Joe Murphy. I'm a lawyer with Allegheny Immigration Group. I practice immigration law in the family and humanitarian applications. This is our weekly Immigration Live. Tonight we'll be discussing the popular 90-day fiancé rule. I know that's a very popular television show, and I'm going to go over some of the things about the immigration law part of the 90-day fiancé, what it's called, how it works, so on and so forth. There's been a lot of interesting calls about it. I'm also going to talk about some of the new immigration rules that the administration is proposing. Before I begin, I have to ask, please share these videos. We're a small outfit, we don't have a big advertising budget, and we rely on people like you sharing these videos for us to get the word out, to have people see our lives and our posts. Some of this is valuable information and people sometimes use it and get value from it, and I'd hope that if you do, you would share it too, please. Okay, with that said, let's get into it. So you've probably seen the show. It's called 90-Day Fiancé. It's about people getting engaged to and marrying foreign citizens. The actual name of the program is the Fiancé Visa Program, or sometimes the K Visa Program, because that's the letter assigned to a fiancé visa. And so whether it's over the internet or in person, Americans meet a lot of foreigners. Sometimes these meetings blossom into romance, engagement, even marriage. And that's what a fiancé visa is about, that space in between there. An American citizen who's become engaged to a foreign citizen can apply for what's called a fiancé visa for that foreign citizen. And when the foreign citizen gets a fiancé visa, they can use that to enter the United States for the purpose of marrying their American fiancé. So again, that's called a K visa. Sometimes it's called a fiancé visa, and it's good for 90 days. It allows the person to enter the United States. They have 90 days from when they enter in order to marry their American citizen spouse. Once that they have to marry the person they're engaged to. They can't marry any American. They have to marry the one who sponsored their K visa, and that would be the original fiancé. They have 90 days from the day they enter to marry that fiancé, and if they marry, of course, they can apply for a green card and ultimately citizenship, and I'll go into that a little bit later. But it is 90 days, and that's why the show's called 90-Day Fiancé. And a lot of funny stuff happens in the show, and I'm sure happens in real life. People are what they are and do what they do. Getting a K visa. Of course, you can hire us to help you with that. Some people try and do it themselves. Some people get away with that. More often than not, people who try and do it themselves end up in my office, or at least the ones that I see. And so my suggestion is to see me or someone like me. Obviously, I'd like you to hire me, but the cost of preparing and filing a fiancé visa is not all that high. There's a legal fee, that's to us, and we work on that. We have some of the lowest fees in the business. The government charges a fee of $535 to do. That's the applying fee. That doesn't go to lawyers, it just goes to the United States. The overseas fiancé will have to get a medical exam from a U.S. approved immigration doctor, and those are called immigration surgeons. Although they're not going to be operating on your fiancé, they will check your fiancé to make sure they're not carrying any horrible diseases or anything like that, tuberculosis, leprosy, communicable diseases that we risk to other Americans if they were admitted to our country. The fiancé visa application is only $535, so that's a nice way to start. Low cost, legal fees are low on that too. It's not particularly hard work for us. It's just very detail oriented, and you want it done by an ALA member lawyer. I'll explain that later too. The process starts with the U.S. citizen applying for a fiancé visa for their foreign spouse, and they have to prove some things. They have to prove first that they are in fact a citizen. That's the basis for their right to file for the spouse. They have to prove that they're engaged, and that's usually shown by pictures from an engagement party, purchase of a ring, texts, chats exchanged during dating and things of that nature, places they went together, so on and so forth. They have to prove that they intend to actually marry, and that's an interesting thing. Both spouses have to submit statements that they intend to marry, and we can help you with that. There's a form we use here. The spouses have to look at the form, and it's basically saying, I intend to marry this person, sign it and submit it as a statement of their intention to marry to the USCIS. They have to prove their ability to marry, and that's interesting. Both spouses, both fiancés, that is, intending spouses, but they're fiancés now, have to prove that they're legally able to marry the other. And that generally means that they have to prove that any prior marriages of both parties have to be terminated, and that could be usually by divorce, but it could be by annulment or even death of the spouse. We'd have to prove that, and we would need the certificate, the divorce certificate, the annulment certificate, or the death certificate if that was the case. In addition to the ability to marry, the citizen fiancé has to prove the ability to financially support their foreign spouse. So the American citizen has to prove that they have the money, the means to pay support this person, because they won't be able to work for a while after entering the United States. And they'll need to do things like eat and have a roof over them. And then this one's kind of a sticker, because a lot of people do meet over the internet, Skype, things like that, online dating applications, and can develop very close and very strong bonds without ever having met in person. The rule still requires that these people, the parties to a fiancé visa application, prove that they've met in person prior to this application. So that can't be online. You have to be like literally breathing the same air. That usually involves the citizen spouse proving that they've traveled to the foreign citizen's country, or that the foreign citizen proved that they've been in the United States and met this person in person here. The non-citizen will get notified by the consulate or embassy in their home country that a K visa application, a fiancé visa application, has been submitted on their behalf. The local embassy will then schedule an interview with them, and before the interview, the non-citizen has to go and see an immigration surgeon for that medical exam that we discussed, proving that they don't have any horrible communicable diseases. They have to get a police clearance from their local police department, and that's a police attestation that these people aren't criminals or troublemakers of various types. Then there's an interview where the foreign fiancé will attend a meeting at the embassy or consulate with an officer of the USCIS, who will make sure they are who they say they are, go over the documents, talk to them about their intentions in the United States, and ultimately, if everything goes well, approve them for a K visa to enter the United States and marry the person who they're engaged to in the United States. The final issue is that they cannot be otherwise inadmissible, and that was sort of touched on when we got into medical examinations and police clearances. There are categories of people who are not admissible to the United States. Even if you're engaged to a United States citizen, if you go to the interview at the embassy or consulate and tell the embassy or consular officer that you intend to engage in polygamy, terrorism, human or weapons trafficking, things of that nature, they make you inadmissible, and even though you otherwise qualify for a fiancé visa, it won't be issued. Similarly, if you fail a medical exam, you are inadmissible to the United States unless and until the condition that made you inadmissible has been cured. And I often give the example of tuberculosis because it's horrible and it's catching, and it would make you inadmissible if you tested positive for tuberculosis. At the same time, tuberculosis is curable. So if you go to your physician, take the course of treatment, usually antibiotic, once you could show that you are no longer afflicted with this, or at least you are no longer contagious, then that inadmissibility would be cured. So everything checks out, the visa is issued. If the foreign fiancé has children, they can be issued K2 visas and can come along as derivative beneficiaries of the K1 visa. And they can adjust again to green card with their parent when and if the marriage is consummated. The 90 days doesn't start till the fiancé enters the United States. So it doesn't start on the day the visa is issued. It starts on the day that person sets foot on American soil. They have 90 days to get married, and that marriage has to be to the citizen who brought them. They can't break up with the person who sponsored their K visa and marry someone else. That's not acceptable. And I always advise people to take their time during that 90 days, especially if you're the American citizen, and that's not any comment about any foreign culture. There are plenty of lovely people all over the world. I'm married to someone who was originally a foreign citizen, and I think that sometimes that can be really good. A lot of interesting things happen, but there's interesting things of a different type that can happen during that 90 days. When you're actually living with someone, it's different than when it's someone you met on vacation. You can see a lot and learn a lot about someone living in close quarters, and take your 90 days. Don't take all of them because you have to get married before it expires, but take your time. Don't rush right into a marriage, and any sane person would give you that advice. If the parties do get married within the 90 days, the fiancé, now spouse, can apply for a green card. That's called a conditional permanent resident card, and it's conditional based on that the non-citizen spouse now be in and stay in what's called a bona fide marriage to the U.S. citizen for 2 years. After 2 years, the foreign now spouse can apply to have those conditions removed, and they'll be in just a regular permanent resident of the United States. If they stay in the marriage for another 3 years, and that means married to and living with the American citizen spouse, then they can apply for and become a U.S. citizen. Of course, there's some things I ought to go over with you. During the 2 years, if the marriage was bona fide and breaks up and it's nobody's fault, everybody got into it with the best intentions, it just didn't work out, the parties can apply for a waiver of the 2-year condition, and the person can still get the green card. Similarly, If there's abuse, the foreign spouse will be able to get the conditions lifted, even though they hadn't done the 2 years. So it's not like 2 years of jail. If this person that you married as a foreigner, this American that you married as some sort of miscreant, or if you were in love and fell out of it just normally, the law accounts for that. But the marriage has to be bona fide, at least at its inception. And for the most part, you're going to do the 2 years. But again, if there's abuse, or if there's just a falling apart, that can be excused, and that person can still get an unconditional green card or permanent resident card. Now, the 3 years after that, if you do the first 2 years, get your conditions lifted, you're happy, everything's going well, you're not abusing each other, you're still in love, and you do another 3 years and you stay married now for a total of 5 years, and you have to have been married and living together. Merely still being in the marriage is not enough. So separated but not divorced won't apply. But if you stay married and living together for the whole 5 years, you can apply for for citizenship at that point. If, however, the marriage breaks up during the conditional period, and that could be again because of abuse or just a falling apart, after you get the conditions removed, then you would have to wait 5 years to get your citizenship. Well, I guess that's it. I mean, that's an outline of the whole thing, from a chance meeting overseas to a citizen of the United States. My name is Joe Murphy. I'm an immigration lawyer with Allegheny Immigration Group. My practice is primarily focused on family and humanitarian immigration. My office number is 412-521-2000. My cell, text, and WhatsApp are all the same number, 412-973-3442. People can and do call me, text me, send me questions all the time, and you can too. So don't hesitate to reach out. Again, my cell, text, and WhatsApp are all the same number, 412-973-3442. And my name is Joe Murphy. I'm a lawyer with Allegheny Immigration Group. Now, I started using this WhatsApp a couple months ago, and I really like it, especially in my business where you're talking to people from all over the world. WhatsApp is free, and you get free calling, text, even video chat. It's encrypted end-to-end, and it's international, so it's good for me. So I always like to say it's encrypted, international, and free. If you want to talk to me, that's great. You can download WhatsApp free for iOS or Android. All your calls, texts, chats, even video chats are free on that. If you want to just text me regularly, call me on the phone. People stop by my office. I'm in the Grant Building in downtown Pittsburgh, and you're welcome to stop by. If I'm in, I'll be happy to talk with you. The next thing is the continuing crackdown on Asylum app. And these are people that are fleeing, in many cases, really terrible and oppressive conditions in their home country. They get into the United States, and that can even be by crashing the border. In some cases, they have no money. In some cases, their passports have been taken from them by oppressive regimes. But however they're able to do it, they get to the United States, and that could be as simple as rushing into an embassy, and they apply for asylum. Those people get into our country, and their status is applicant for asylum. After they have applied for asylum, eventually they can get a work permit. In many cases, they have to wait quite a long time to even have their first hearing on an asylum case, and these people have to support themselves while in our country. Otherwise, they end up working as an underclass under the table, or God knows what else. The rule historically has been that after 180 days after the initial application for asylum, that the applicant can then apply for a work authorization, work papers, if you would. The new waiting period before they can even apply has been extended from 180 days to 365 days, and that's a lot of time to wait without any income. The work permits will have shorter durations. Only people who entered a designated port of entry will be able to get a work permit. So people that walked across a border, they won't be able to get a work permit at all. Only people who apply for asylum within 1 year of entering the U.S. will be able to get a work permit. But now they're saying, and it doesn't matter, we don't care, right? If you apply for asylum at any point after a year, you're not going to be able to work. That makes it very difficult. It makes asylum much less attractive for someone applying. Like, what am I going to do? I'm never going to be allowed to work until my application is adjudicated. So there's more to it, of course, but this is just another in a series of changes the current administration is pushing for. It's similar to the public charge rule they had, or the rule that they wanted anybody who was coming in the United States, even tourists, to prove they had medical insurance. This will go into effect at some point in the future. I don't have the effective date, but the actual draft was released this morning. Ultimately, when it goes into effect, lawyers like myself will sue the administration and get injunctions, and it'll be litigated. But this stuff is coming, all of it. The public charge stuff, the medical insurance stuff, and now this shenanigans with work permits and asylum seekers. I'm encouraging everybody who's thinking about this, if you're thinking about an asylum application, it's time. This is not going away. And in one form or another, most of these things are eventually going to weed their way through the system. And you're going to be facing a much less friendly and much more hostile system if you qualify at all. Asylum is a very important part of my humanitarian practice. And if you think you have an asylum claim, I'd like to talk to you. So give me a call. My name is Joe Murphy. I'm a lawyer with Allegheny Immigration Group. I practice family and humanitarian immigration. Our office number is 412-521-2000. My cell, text, and WhatsApp are all the same number, 412-973-3442. Don't hesitate to use those numbers. I'll be happy to hear from you. People call me all the time, and you can too. Sometimes at odd hours of the morning, and if I'm awake, I'll take your call. All right, on that note, okay, I'm telling you now to get your asylum applications in, but I want you to be careful of something. There used to be kind of illegal underground businesses. These people would deal in stolen cars, right? Criminals would steal cars, take them to these places called chop shops. And the chop shops, in some cases, would chop the frame of the car, but before they did that, they would strip off all the parts and sell them for profit. The frame itself had a serial number which was registered to someone and revealed the car was stolen, but there's no serial number on the tires or the battery or the drivetrain. So the chop shops were criminal organizations stripping a car down to its bare bones and selling off the parts. There are asylum chop shops. These are people who, they really only fill out the paperwork and they give you a bare bones application. There's no investigation into your case. They just want to get a fee off of you. In many cases, these people, they do no research. They won't sign the application as someone who helped you prepare it. They may not be lawyers. They may not know what they're doing. If you look at these regulations, there's provisions about dealing with incomplete or improperly prepared applications. You could get a chop shop lawyer to put something together and slap up some junk asylum case, but these new regulations are going to punish you, and I assure you there will be more coming after them. This is specifically what these regulations are targeting, these kind of asylum factories or chop shops or mills, if you want to call it. So you want to look for some things when you're dealing with someone who's quote unquote helping you with an application. The first thing, and I tell you, is you want to use an immigration lawyer. Ideally, an immigration lawyer who's a member of AILA. That's AILA, the American Immigration Lawyers Association. I'm a member. There's plenty of them. There's an AILA directory, AILA. You can see it online. Easy to find. But you'll find people that aren't lawyers at all, don't know immigration law. Anybody can fill out a form, anybody with a basic working knowledge of the English language and a typewriter. There's more to it than that in an asylum case. These cases have to be investigated, researched. You have to, in many cases, prepare a brief and submit it with it, even if it's just to the Arlington office. You don't want to be putting these bare bones up. They were never a good idea, but the new regulations are going to severely penalize bare bones, chop shop, asylum mill type of applications. I'll give you some hints on when you know it's a chop shop. There's no research into your claims, or they tell you not to worry, it'll be years before it even gets to court. These are red flags. The person helping with you doesn't have an office, or you don't know where they live, or you don't know their name. If the person helping you is way smarter than all the lawyers, you're probably dealing with a chop shop. If you think you're dealing with a chop shop, you probably are. You have intuition. Even if you're not a Native American, you have basic human intuition. If you do this, you're going to get in trouble. Right? You can end up deported, in jail, or in both, and it's just not worth it. It may seem like your only option is to deal with these puppy mills, these immigration factories, but any decent immigration lawyer will work with you, and if you really truly don't have the funds, almost all of us can refer you to charitable organizations where they have perfectly competent volunteer attorneys who will prepare the application for you at no fee. So again, my name is Joe Murphy. I'm an immigration lawyer with Allegheny Immigration Group. My office is in Pittsburgh, but I practice all over Pennsylvania, West Virginia, Ohio, Maryland, Virginia itself. My practice is primarily family and humanitarian immigration. My office number is 412-521-2000. My cell, text, and WhatsApp are all the same number, 412-973-3442. People call me, text me, ask me questions all day long, and you can too. Don't hesitate to reach out to me. I'm happy to talk about it. I like what I do. But I think that's the end of my show tonight. We talked about the interesting phenomenon of the 90-day fiancés. We talked about changes to the rules controlling how and when asylum seekers can get a work permit, and then I warned you about asylum chop shops. If you have questions about any of these topics or any immigration topic, don't hesitate to reach out. Again, my cell, text, and WhatsApp are all the same number, 412-973-3442.